Your Honor, ladies and gentlemen of the jury, opposing counsel, and co-counsel. Now, ladies and gentlemen, we've heard a plethora of terms thrown around today. Distraction, personal electronic device, and even such inflammatory words as brat, idiot, and troublemaker. But, ladies and gentlemen, there is perhaps one term that is perhaps the most important of all in this case: negligence. It is your duty, ladies and gentlemen of the jury, to decide who in this case was negligent enough to cause this terrible accident. Was it the defendant, the driver, or was it the pedestrian, Ms. Peterson? We, the plaintiff, submit that the driver, Mr. Moody, was clearly more negligent and was the causative factor of this accident, in keeping with the expert conclusion of Dr. Delaney Jones. We introduce you to three witnesses today who have allowed us to present our case to you, ladies and gentlemen of the jury. Mr. Maury Christie, a now graduated honors student of Metropolitan High School; Dr. Delaney Jones, a veteran civil engineer with a specialty in roadway safety; and the victim of this accident, Ms. Jordan Peterson. Mr. Christie established for us that the defendant was upset upon getting into his car, that his emotions were not in control. He also told us of how the defendant looked down at his phone while driving, rather than at the road ahead of him, the road where Ms. Peterson was. Mr. Christie stated himself in cross that he had no ill will toward Mr. Moody at all. They were friends, and that was that. The defense also had Mr. Christie state that since he looked up when the car behind Mr. Moody's car honked, he couldn't make an accurate evaluation of what had happened of Peterson walking in front of the car. But then again, Mr. Moody also admitted that he was looking down at his phone until he looked up when he heard the car horn. So, can we really trust Mr. Moody to make this same statement? Make a statement about Ms. Peterson walking in the street? We submit that we cannot. The good Dr. Jones related to the court just exactly what distracted driving was: a brain issue, a cognitive problem. When too many parts of the brain are interacting and doing different activities, rather than driving a very mentally demanding process, the driver is unable to perform to the best of their ability, or is distracted. Now, Dr. Jones told us that the performance of a distracted driver was like that of a drunken driver, and it is widely known the mass numbers of accidents caused by intoxicated drivers. Upon examining all the facts in this case, Dr. Jones came to the expert conclusion that the driver, Mr. Moody, was distracted and therefore is at fault for this accident. The defense would have you believe that Dr. Jones had a bias against distracted drivers due to a tragic accident in her family, but this accident happened 4 years ago, while Dr. Jones has been researching and working with distracted driving for over 25 years. Jordan Peterson then came forward and told us how she was walking along, enjoying some music, when she looked across the street. She saw the defendant's car and believed because of how slowly it was moving, she was being allowed to cross. Sadly, it was clear that the defendant did not even see her, for as she took her first steps across the street, she was struck by Mr. Moody. She also told us about an assembly her school had held regarding distracted driving, one that we submit the defendant did not attend. Ms. Peterson also stated for us that she did not wait for Mr. Mills to signal her to cross the street, Pterodactyl Place. However, Mr. Mills stated that his job was to guide kids across Main Street, not Pterodactyl Place. So why, ladies and gentlemen, why should my client have to wait for a signal for a crossing guard that was working at a different location? The defense then brought out Chris Mills, the crossing guard. Now, the defense tried to pull our heartstrings by talking about the defendant's deceased wife, but as the defense stated, we should look at the facts and not care about emotional ties to this case. Now, Mr. Mills didn't have much of a story to tell us, mostly because of the discrepancies between his version of the events that transpired on the day of the accident and the versions of other witnesses in this case. He claims that he called the students telling them that help was on the way. No other witnesses commented on hearing him call to them. He claims Mr. Christie was fiddling with a gadget when no other witnesses stated that Mr. Christie was using any type of device upon entering the defendant's car. He even told us there was a group of students. Oh, I'm mistaken. Mr. Mills also stated for us that he was not wearing glasses. Now, Mr. Mills also stated that he was nearsighted, so he could see things that were far away but not close. But since Mr. Mills was not wearing glasses, he must not have been wearing sunglasses, and therefore had no protection from the sun that was glaring off of the bright red metallic Corvette that the defendant was driving. Not only that, but while he may deny it, it is clear that Mr. Mills has a bias against Mr. Christie and Miss Peterson, referring to them in such inflammatory words that an unbiased person will never use. How can we trust anything that Mr. Mills has said to us today? And next came Dr. Haley Collin, a psychologist. Dr. Common's junk science study used a hardly sufficient number of test subjects to prove a point for the defense. However, with such a small amount of subject data, we cannot even be sure if his results are accurate ones. His study never states anything about cars moving less than 10 miles an hour, as the defendant's was. And his studies never even touch on the possibility of the driver being distracted as opposed to the pedestrian. Dr. Common made an expert conclusion that Jordan Peterson was at fault for this accident, directly opposing Dr. Jones' expert conclusion. However, Dr. Common is a psychologist, while Dr. Jones is a civil engineer with a specialty in roadway safety. Ladies and gentlemen of the jury, I submit that the negligent party in this case is obviously the defendant. Entered his car while upset, something all new drivers are taught never to do. He had a duty not only to watch the road, but to check for any pedestrians in his general vicinity, which he did not do, for he did not see my client. Mr. Moody became distracted when he decided that checking his phone was more important than checking his surroundings. The defense has argued over and over again that he only breaks down for a moment. But as Dr. Jones said, distraction is a problem in the brain. If the brain switches focus to something else, a phone for instance, you have become distracted and therefore become a risk to drivers as well as pedestrians. The defense also stated that checking one's phone, glancing down for just a moment, would be the same as adjusting the air conditioner or adjusting mirrors. But Dr. Common concluded in her master thesis, Dr. Jones concluded in her master thesis, that doing such acts are distractions. The defense has tried to show to you, ladies and gentlemen of the jury, that looking at the phone is not a distraction because it's like other distractions. Does this make any sense? It is up to you now, ladies and gentlemen of the jury, to determine who was at fault in this case. Was it Jordan Peterson, the student who was walking along enjoying some music? Or J.E., the defendant, the student who neglected his greater duty in order to check his phone? Let's give the defendant a wake-up call to the real world, and please make a verdict in favor of the plaintiff.